What began as a statement of solidarity outside Harare's Magistrates Court by Joanna Mamombe, Cecilia Chimbiri, Netai Marova and Zinasu student leaders has turned into a nightmare. The trio, who stood unshaken demanding the immediate release of MDC Alliance youth leader Makomborero Aruziwishe, spent the week battling for freedom from the shackles of government, which is holding them in remand prison on allegations of wanting to foment chaos. Since Monday, the trio started their day by being chained and transported to court for an agonizing bail application. Prison officers have now made it a point to shield the accused persons from the glare of the cameras. As the trio neared a week-long detention, opposition leader Nelson Chamisa, accompanied by his vice chairperson Job Sikala, attended court Monday in solidarity. He addressed the press briefly, saying detaining the young girls on International Women's Day exposed President Emmerson Mnangagwa's government to the international community.
Well, it's a big challenge, clearly showing that we have more problems than we had even under Mr. Mugabe. So it's an issue that we need to deal with, and it's an issue that requires all of us to come together to deal with the breakdown of rule of law. Particularly now, we have these ladies whom we had to come to give support and to try and manage, because it's International Women's Day. So we wanted to manage.
Can you finish your statement?
Well, today is International Women's Day, so it's important to also honor the women who are being persecuted, the women who are so committed and dedicated. Thank you. Thank you. Yeah. Thank you. Yeah. So Thank you. Thank you. All right.
In court, Mamombe and Chimbiri, who are jointly charged, were having a draft before Magistrate Wongai Muchuchuti Guriro as the straight-through spanners in their attempt to freedom. The state told the court that the duo are habitual offenders who are doing everything in their power to avoid facing justice. Michael Reza was charged, saying it was better to keep the two MDC alliance leaders in the pen. Their lawyer, Charles Kwaramba, fought a losing battle, telling the court his clients were yet to be convicted of any crime and could therefore not be labeled habitual offenders. Despite promising to deliver bail ruling on Wednesday, Muchuchuti only announced her decision Thursday when she denied them bail, after classifying them as persons with a propensity of committing offenses. We'll round up on the lawyers' updates on Monday, Wednesday, and Thursday.
We went to court this morning expecting to be given the ruling on the bail application that we made on Saturday. The magistrate advised that she was not yet ready to furnish us with the ruling. She indicated that she wanted some clarifications to be made by the state on whether or not the offenses they are facing are similar, if so, where is the similarity, and secondly, for the state to also explain the delays that are being experienced in terms of having those matters taken for trial. The clarifications were given, after which the court then said it will hand down its ruling on Wednesday at 11:15.
In tomorrow's ruling?
In respect of Joanna and the other one?
Yes.
Well, we're always expecting better things to happen. We always think that these people shouldn't be in court in the first place. But unfortunately they are. And we have made our bail application. We are very hopeful that they'll get bail. We can't anticipate what the court will do. We have no power over what the court will do. We can only wait and see what the court will say.
So maybe you can just provide a quick update on what transpired regarding the bail application for Joanna Mamombe and Cecilia Chimbiri.
Well, as you may know, we applied for bail in respect of those two who are facing allegations of. Okay, so as you may know, we applied for bail in respect of those two who are facing allegations of breaching COVID regulations. So the ruling has just been made by the court. Bail has been denied, We are obviously disappointed. We are not happy about the ruling, and I can't say we're surprised, but we are obviously disappointed. And as you know, the court is entitled to make its decision, and accused persons are entitled to disagree. We disagree with it. We obviously take the next obvious route, which is to appeal against this dismissal of the bail to the High Court, and hopefully a different outcome will be achieved.
On the other end, Netai Marova's week ended with joy after she was cut loose and released on a 15,000 Zimbabwean dollar bail. Magistrate Usheone Sumatova ruled that Marova, accused of beating up a police officer, had no previous convictions and therefore cannot be classified as a person with a propensity of committing crime. She was asked to reside at her given address and surrender her passport to the clerk of court.
Marova is facing the charge of resisting or assaulting a peace officer. So we appeared in court today, and we were making submissions pursuing bail to be granted in a favor. So the state was opposed to bail, so we made submissions in court, and the court has reserved its judgment. So we expect to receive judgment tomorrow at 11:15 in respect of the application for bail.
Okay, so what was the outcome in court?
So as you know, we applied for bail in respect of Netai Marova, and so the court has granted bail in the sum of 15,000, and then she was ordered to report at the police station once every 2 weeks. So she's out on bail now.
Marova's father, who was ecstatic after the granting of bail of his daughter, spoke to the media.
It's quite disgusting and very, very shameful for a court like this regional court to give such a verdict. So far, we have realized that the court here at Rotten Row will never give bail to these two girls. But let me reveal the truth. There is a war, a hostility behind the background, behind the doors of my daughter and the magistrate who took over charge today to give a ruling of no bail. I would want to reveal that she must recuse herself and she must actually move out of this case because she's being actually told what to do by Mr. Reza, who is Reza Michael, the state prosecutor. Let me reveal the truth. The truth is that at one time my daughter had a fight with Wongai, the magistrate, Muchuchuti Guriro, over a boyfriend. I put that. If she has anything to complain about, I didn't want to talk about it because I know now she's married. I didn't want it to cause problems in her family, a new family. But it appears as though she still has a vendetta with my daughter over that boyfriend. And the ruling has nothing to do with the case which happened here. The case which involved Professor Lavo Madugu, who was actually exonerated from the same case. The case that happened here, which has already also exonerated Netai Marova, who has been given bail. Why these two girls? It means the state has got a hand in operating as a pariah state. The state has got a hand in denying bail. Chapter 49, so section 49 of chapter 4 of the Constitution of Zimbabwe is being actually scribbled. I'm hurt, and I will tell the truth, and I will never rest. If they are actually aiming to kill my daughter, they will see the best back part of my body. I would also want to say Reza must recuse himself from this case. Reza is also supposed to be on suspension because he has got a case of fraud, that of a certificate about the diamonds of this Chinese guy. He is under investigation, but he is coming just for this case. He is supposed to be in Manicaland as a regional prosecutor there. But he comes just for this case. Are you telling me he is the only super litigant, super prosecutor who can actually do work here at this place? I'm hurt. Reza must recuse himself. He must stop this vendetta against my daughters. This is no longer by the book, but by an individual crippling of the law in the pocket. This law We refer it from our Zimbabwean constitution, which we all agreed in 2013, that everyone has got a declaration of rights. We are all humans, but he is dehumanizing my daughters. He is incarcerating my daughters. Why does he have the powers to just send these daughters to prison when the case has not been finalized, it has not been tried? Let me tell you, Reza does not want trial for these girls. For 10 months, 124th time coming to this court. This is the 124th time. Let me repeat it again. This is the 124th time coming to this court every day for these girls. And he doesn't want a trial. Why does he not want a trial? Because he does not have evidence. If he wants it, the trial must start as soon as possible. But what he is doing is he's sending the police, using the police so that he creates what he is calling propensity of committing crime. There's no case or there's no propensity when the police arrest daughters who have come to report at the police station on their bail conditions, and you arrest them, and then you say they've got a propensity of creating crimes. Reza must stop this. God is watching, and it is now time. The rule of law will be upon him.
Nothing. There is no change.
Oh.
It's almost the same. When you're out of custody and we are here, it's almost the same. Actually, we feel safer in Chukuruge than out here. Yeah, because in Chukuruge, at least we are protected. The prison officers can take care of us very well. But when we are out here, I don't feel safe because of the ferret, the police that is continuously victimizing us. We no longer know their intention and their acts now. Yeah. But just being home, of course, it's better than being in Chukuruge. That's why I just hope for the best for my colleagues today, for their ruling today at 2 p.m.
In another case, the Norton legislator Themba Mliswa was back in court challenging his replacement on remand, telling the court his arrest was unlawful. Magistrate Tafadzwa Miti, however, dismissed the application and refused to remove Mliswa from remand.
As we had intimated in after our initial court appearance, that on our next court appearance we'll be challenging the legality of the arrest itself and placement of remand of Honorable Mliswa. We have commenced that process. We made extensive submissions on that, and the state has requested that the matter be rolled over to tomorrow for them to give their response. So we wait for their response tomorrow. Yesterday we made submissions challenging the legality of Honorable Mliswa's arrest and subsequent placement on remand, and the state had requested that the matter be deferred to today for them to give their response. So they finished their response and we have answered to that. We now await the determination of the application, which has been penciled for tomorrow morning at 9:30 a.m.
Oh, okay. So maybe you can update us.
Okay, we have just come out of court with the Honorable Themba Mliswa, where we were listening to the ruling by the court on our application challenging the legality of Honorable Mliswa's arrest and the subsequent placement on remand. The magistrate has determined the matter against us, but of course we totally disagree with the reasoning that has been put forward for the findings. And by virtue of the fact that we of the considered view that this matter is hinged upon the constitutional rights of Honorable Mliswa, we have placed the state on notice that we are going to be lodging an application for referral to the Constitutional Court of the issues that relate to Honorable Mliswa's right to liberty, as well as his right to immediate or prompt release in circumstances of an illegal arrest. As clearly the arrest was illegal, it was not in conformity with the provisions of the statute in terms of which he was arrested, that is Statutory Instrument 200 of 2020, and further the circumstances that arose with regards to the matter are circumstances that are clearly canvassed and covered as exceptions to the general rule that establishes the offence in terms of the same statutory instruments. A reading of Section 5, subsection 1 of SI 200 of 2020 clearly reveals the fallacy of the arguments that have been advanced by the state and the finding that has been made by the court. But of course, we accept the finding. We are mortals and we have a duty to observe and agree or accept to live by decisions that have been made by judicial authorities. But the good thing is that the Magistrates Court is not the be-all and end-all of judicial processes. So we are going to activate the necessary processes with Superior Court, which we believe totally agree with our position. So in short, that is our...
Okay, so do you think the government is applying the law fairly or is being used to oppress other people?
In this particular instance, I would be inclined to say no. Because, for example, on the same day that Honorable Temba Peter Mliso was arrested, a similar gathering was convened, a similar gathering of journalists. A press conference was convened by Professor Maduku. He was not arrested. We have seen many press conferences being held. The former Vice President Kempo Mohadi recently held a press conference announcing his resignation. No one was arrested. The President himself occasionally holds press conferences. Press conferences are being held by the Minister of Information each and every day that they leave cabinet. No one has been arrested for that. But because this particular press conference has been held by Temba Peter Mliso, he has been arrested. So in answer to your question, I would actually hazard the view that yes, this is not uniform application of the law. Honorable Mliso has not been accorded to his constitutional right to equality and equal protection of people. That is my view.
So, Honorable, what do you have to say on the application of the law to Zimbabwe? Is it being applied fairly or being used against certain individuals?
Listen, I'm a legislator and there are structures in the country that deal with the fairness of any issue. There are three pillars of the state: the executive, judiciary, and the legislature. And each one has a role to play to ensure that there is fairness. And I have no doubt that the truth will come out. It's just that it takes time. Like Mr. Ungwe said, this is just the Magistrates Court. There's the High Court, there's the Supreme Court, there's the Constitutional Court. And that's the reason why we have those pillars to be able to put this whole argument before a proper court. And I've no doubt that justice will prevail at the end of the day. Not for me, but for many others, because the precedence has got to be set. The way the law is applied has not been fair. So I think we now need to have people not abusing certain statutory instruments to achieve their personal goals and so forth. We are politicians and we have our own fights, but I don't think we should now reduce to institutions being used to also fight one. If I've insulted you as a minister, then sue me. But you don't use the state apparatus to be able to do that. I'm a legislator. I have the right to represent people. If the Commissioner General of Police, Goodwin Matanga, is being accused of being corrupt in tender procurement, I raise these issues for national interest because the President is very clear on zero tolerance on corruption. So if we don't speak for the people, who will speak?
This was the Court's Weekly Roundup by Gaddafi Wells and Wimbai Majaha.